I hope it's prison time.
Okay.
You Taylor Lloyd Sadlicek?
Yes.
Okay. Just pull out some others.
Prison time.
What we might need to do with. All right, here's Weston's two cases. And those are reset Zarate's two cases.
It's not even true. Look for me.
Mike?
Yeah.
Okay. How you doing, Brian?
Nice to meet you. Nope. I think so years ago. I'll look at some of that. I'll get some more stuff from new business. I'll sort of want to take the
7 cases are now called. Mr. Sadlicek, did you understand that there were 7 as far as you knew pending cases?
Yes.
And we're just going to make sure you understand what they are. I know Mr. Grover's told you that, but in 23 CR 179, you were indicted in April 2 years ago. Why? Has he been somewhere else?
He was not in our custody for a long time. He had a warrant out.
Okay, were you in custody somewhere?
No.
Okay, you were out somewhere.
I believe
You
he was
lived
in California.
Free person somewhere. Okay. So they end up arresting you sometime. When were you arrested on these cases, you know? Bound. Yeah.
Yes.
March of 23. That was before you were indicted. You were arrested before you were indicted, though, right? Later, the indictment comes out. And did you ever appear after that?
No, so they
Until
looked
now.
at an accusation and I didn't know what that was, so I was. Lost, so I had that moment. And then, yeah, I got picked up.
Where have you been living this whole time in Beaumont?
No, I live in California.
Because I've got a 3565 Delaware Street address here.
Yeah, that's where I got arrested. And I was resigning.
Was that a residence of yours?
I was living with a friend in Wisconsin.
Well, that's where you were residing, though.
In both, yeah.
Right, this alleges the on or about February 28th, 2023 in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction or retaliation. If convicted of such a thing. And it goes on. Are you familiar with what these charge, what you're charged with and what they allege? Okay, it looks like threatening a police officer.
Not all of them, Judge.
I know, I'm just taking one at a time,
Right.
179. Okay, that if convicted is a 3rd-degree felony, so you look at no less than 2 nor more than 10 years confinement in prison and a fine up to $20,000. Yeah, that's all that was indicted on that. You understand what you're charged with and what the punishment range is there.
Yes.
Okay, in 23 CR 180, I'm going to take these in numerical sequence. In 180, you were indicted on April of 23 for 3rd-degree felony of harassment of a public servant. Must have been something that happened on the same event, February 28th of 2023, by apparently spitting upon the officer attempting to arrest you. That is also a 3rd-degree felony, which is with the same punishment range that we talked about before. No less than 2 nor more than 10 years confinement in prison and a fine of $10,000. Then 23 CR 181 on that same date alleges harassment of a public servant. Must have been more than one police officer involved, I'm thinking.
Yeah.
And this is a 3rd-degree felony, which again carries the same punishment range, no less than 2 nor more than 10 years confinement in prison and fine up to $10,000 to be assessed. Also on that date, you're charged with something that occurred on that date by the grand jury. Also in this April 23 date, April 26th, with another indictment, 23 CR 182, the 2nd-degree felony of assault on a peace officer. And it is a 2nd-degree felony. By causing bodily injury, it becomes a 2nd-degree felony. So you are looking at no less than 2 nor more than 20 years confinement in prison and a fine of $10,000 can be assessed. In 23 CR 183, you were charged also on the date with another 2nd-degree felony of assault on a peace officer, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. And finally, 23 CR 184 charges you with the second degree felony of burglary of a habitation. An event on or about that date, I guess, when this was occurring, the police go out to investigate, and then a ruckus occurs apparently. And you're looking at no less than 2, no more than 20 years confinement in prison and a fine up to $10,000 in that case. So apparently there's 4 cases that are second degree felonies and 3 that are third degree felonies. So
Indecency. Did you find that one? I believe all the offenses involving a police officer arose out of the warrant for that burglary and the indecency, I think.
there is an indecency with a child here, 23 CR 185, which alleges on or about February 28th, 2023 in Jefferson County, Texas, you committed the second degree felony of indecency with a child. So that carries with it again the same punishment range 1
That's
that we talked about for second degree felonies. 2,
I had no idea.
3, 4, 4 second degree felonies, which and 3 third degree
That's
felonies.
correct, John.
So you're looking at up to 110 years in prison and fines. These are 250,000 each.
10,000.
10,000. Fine up to $10,000. So that's $70,000 in fines. So you can see there's a lot riding on how you dispose of these cases because 110 years is a lifetime. The end of the day. All right. Mr. Grove, it's an announcement. What are we doing today?
Judge, I've spoken with Mr. Sedlak more than one occasion, spoken with him last Friday. And he indicated he wanted me to tell the court that he wanted another lawyer appointed. As the court can tell, these are second and third degree felonies, all of which allegedly occurred on the same day, which I mean, it's just the way that it is. I don't think that Mr. Sedlak wants his cases set for trial yet, but I've had difficulty investigating.
What is it he's talking about that you need to add to
I
help me?
really just want to see like what evidence is gathered, you know?
Okay. He's supposed to help you with that.
Yeah.
What else? I mean,
Um,
yeah, I mean, this is something that needs to be deliberate and it may take a little bit of time because each case stands on its own merits of allegations. The grand jury has carved out 7 crimes here. So the evidence may certainly be a little unique in each one, but a lot of overlapping since it's all in the same episode.
would I be able to take the trials separately?
Yeah, you can try these separately and then they'll be stacked, whatever the sentences would be stacked. Yeah. That's what generally happens.
But
It would be up to the court.
Right. It'd be the court's discretion.
And that's what the court's practice has been for 19 years.
That's it found guilty though, right?
Oh, yeah, you're presumed innocent. Yeah, I wrote the article on that, lead article on that. Yeah, it's part of the Constitution. Goes back to the Bible.
Yeah, really, I want to know what evidence said you got against me.
Yeah, you're presumed innocent unless found guilty, not until, unless. Until means you're going to get found guilty. It's just a matter of when, unless may or may not happen. And unless is the proper term. That's the way it was written in the Magna Carta in 1215. Is what we took off from. But anyway, and David Grove has been practicing law as long as I have. All right, we were in the DA's office together way back when. Smart guy, Baylor grad. Baylor has great grads. All the law schools in Texas are good, but Baylor is exception. That's it. He graduated high in his class, so he knows his stuff. So he's been practicing for 40, since 78, 79, I guess. Or so, 80.
Yes, sir. No,
Yeah.
no, 78.
78. Yeah, he graduated before me.
And Judge, just for the record, we have given Mr. Grove discovery in all these cases, but just from what I'm hearing right now is the defendant is not entitled to copies of reports and things like that. He
Is that
cannot
what
get
he's
those.
asking for?
It
Is that
sounds
what
like
you're
to me,
asking
but
for? You're entitled to have your attorney will get them. And then he'll go over them with you and he'll show them to you, but you can't have them to be kept because they can be used in an attempt to subvert the witnesses, and that constitutes an additional wrongdoing. So the rules provide your lawyer gets to act on your behalf, and he has free access to all evidence that may be used against you. And you have a right to have that reviewed so you understand where it will apply. You were present, so you know most. I guess you were present. Maybe it was somebody else. But if you were present, you know what to expect and what you're looking for in there in the evidence. You know, so for the most part, sometimes there's other things police find out when the defendant is not present by their own investigation outside the event where you may have or may not have been arrested. Anyway, you need some additional time, obviously.
Yes, sir. And I think that, and I have no objection to Mr. Sedlak receiving and reviewing the statements and that type of thing. I just can't leave it all there with him.
Well, that's true. And no evidence is left with you because you can, sorry, I get to go first on all times. No, long ago, the attempt was made to try to do that sort of thing, and then defendants would ruin the evidence or something like that, you know, and so that's preventable, and every jurisdiction has taken steps to, you don't get to touch this stuff with an attempt to ruin it as an admissible piece of evidence in its form that needs to be kept in, preserved. But you get to know what it is, and you get to be able to analyze it on your own, go, oh, that doesn't have anything to do with me. I'm not worried about that. Or, oh, well, wish that wouldn't have happened. You know, that kind of stuff. But you and he work to get that together. And he's been a trial lawyer longer than I have. A good lawyer.
I wasn't expecting like physical copies of this. I just wanted to know.
No, he can go over with you. He should have it with him he'll have it. Certain things, he can't bring in a blood specimen to you to show it, but he can bring in the records and reports that relate to things and go over them with you.
Yeah, so far I've only heard of a witness or victim statement.
Okay, he's working on it, I'm sure. How long has he been on your case? Do you know?
And 9 months.
Okay. I don't know. You're gonna go see him with all this stuff?
Yes, sir. We've spoken some, but obviously we haven't
7 cases are gonna be.
gotten around to looking at all the evidence, but I will, if the court wants me to stay on the case, I'll be happy.
Yeah, that's the way it works. Yeah, you either stay on them or you're off of them.
Yes,
Because, I mean, they're all important, as important as the next one, and we can only do so much at one time. With the 22nd largest county with the 16th highest crime rate. I'm not proud of it, but that keeps us all busy. So there's a lot going on, but your case is important to you. It's the most important thing to you. Freedom is at stake here. He'll go over it, and has there been anything in negotiations to resolve this that you?
Question I was going to ask, Judge, I've offered, prior to this hearing today, I offered 10 years on the child case. And I guess, are they wanting me to leave that offer open?
No, but you got 7 cases.
To resolve the child case only and
What about
dismiss the rest.
And dismiss the rest? Okay, all right, well,
yeah,
that's something y'all need to know how
That
realistic that is from your
They
point of
haven't
view. But
rejected
the
that
point is we won't try this stuff necessarily together. I'll try it. My practice is try it one at a time, but what happens is 7 cases never get to 7 trials. They never do, because it stacks up so much so quickly generally that there's no reason to try after 2 or 3. And that's an analysis y'all have to make. Anyway, I'm going to give you 4 more weeks.
yes, sir.
And we're gonna come back and y'all tell me which direction we're gonna go in, okay, everybody? But the child, the indecent, is it indecency or sexual assault? I can't remember.
Indecency, sexual contact, so
Okay,
second degree.
that would be tried first.
What constitutes this indecency exactly?
Well, the indictment should tell you. Here, give me that.
Right.
Here, it's, the indictments are worded directly from the statutory element. And I think it was the last case. All right, on or about February 28th, 2023 in Jefferson County, Texas, with intent to arouse or gratify the sexual desire of any person. Generally, it's inferred the defendant, but it could be the attempt to arouse or gratify the sexual desire of any other person. And yet contact, it says you engaged in contact with a person's name who is a child. I'm not going to name it for the world to hear. Hereafter styles the complainant by touching the genitals and breasts of the complainant, a child younger than 17 years of age, against the peace and dignity of the state. Now, the only thing, sometimes people get, sometimes defendants go, aha, I did something with the breasts, but not the genitals, or vice versa. The way the law in Texas, the indictments, when there's more than one way alleged that a crime can be committed by touching the genitals or touching the breast or both. But either one constitutes an indecency if proven beyond a reasonable doubt. But it's alleged in genitals and breast. Sometimes I've heard them say, oh, well, I may have done one, but not the other. Gotcha. They can indict. It's been long the rule of law. You can indict in the conjunctive and prove in the disjunctive if the statute allows disjunctive in the elements of the crime. So I'm saying that because not long ago somebody said, I'm charged with this, but I did this, but not the other one. I said, that wasn't a wise thing to say because that's provable and that's all it takes. If proven beyond a reasonable doubt. But Mr. Grove knows that. And he'll go over with you. Okay, I'm going to give you 4 weeks. Okay.
Thank you.
Can we approach one real quick, just a quick one to get it out of the way?
Yeah, I don't see anybody else on the indictment. That's why I didn't call anyone else. But come
I
on,
think it was.
is add-on?
An add-on.
Okay.
We were going to do a bond hearing, but he's got a parole hold on him, so there's no sense in.
Michael, back on, I'm Murray Newman.